Hi, I'm Paul Vacheski, NebraskaLandlord.com, and we're moving on to the next section here, and we're going to be discussing deposits, security deposits, pet deposits, and what has to happen. I would tell you that of all of the disputed items within the landlord-tenant relationship, I would tell you that that's probably the one that's the most disputed. Whether it's disputed in court or disputed, with fists between the landlord and the tenant, that's the one. Because here's the deal. I've been doing this a long time, and most of the time, most tenants believe no matter how badly they trash the property, that they're entitled to 100% of the security deposit back. And many landlords, no matter how good the tenant returned the property, feel that they're entitled to 100% of the security deposit, and therefore is the dispute, okay? So there is a strict process that we have to follow as landlords and property managers. All right, so having said that, I'm going to tell you what's technically required under the law. Whether you practice that strict construction is up to you. I'm just telling you the process. The other thing is to understand this. The best defense against anything is not to go to court in the first place. I think we all know, we've been in this business long enough, most of us know that we never want to go before a judge if we don't have to, because you never know what the judge is going to do. I was doing an eviction one time. I was kind-hearted and gave them an extra month, my fault, but they had, my tenant had 2 months actually that they didn't pay the rent, did the 3-day notice, evicted them, a sob story in front of the judge. The judge said, well, if I gave you a little bit extra time to get out, how much would you need? And the guy said 60 days, and the judge said, fine, I'll give you 60 days. My attorney was, oh, wait a minute, what's going on here? And the judge said, if you don't like it, appeal it. So again, we don't know. It's like a box of chocolates when you go in front of a judge. So that's why I'm teaching this from the strict constructionist method here. So number one, who can tell me what's the maximum security deposit we can charge? If the rent is $1,000 per month, what's the max deposit? Anybody? Okay, $1,000. So the most that we can collect is equal to 1 month total of the security deposit. That's the most we can collect. So at this point, we've collected $1,000. Now notice I said collected and not charged. This is not rent. This is the tenant's money until a future date when we keep all or some of it legally. Maybe they didn't pay some of the rent or rents, maybe they did damage, so on and so forth, late fees, whatever the case may be. The point is the max that we can collect is $1,000 if our rent is $1,000. It's 100% of the rent price. Now, pet deposit. The other thing we can do is collect, again, notice I said collect, 25%. Oops, I put a dollar sign there. 1/4 or 25% of 1 month's rent, right? And I can't spell very well, that's all right. So in this case here, where our scenario is $1,000 of monthly rent, we can collect in the security deposit a total of $1,000 or equal to 1 month's rent, but we can't collect more than 25% of 1 month's rent as a pet deposit, which is a total of $250. So when we total up the total amount of deposits that we can legally collect in this scenario, we can total here $1,250 in deposits. That includes the security deposit and the pet deposit that we can collect. Is there any question on how I came up with that? Okay. The other thing I want you to know, and I see this all the time, 2 things about pet deposits. Number one, they're the same as the security deposit. It's just an additional amount that we're allowed to collect under the statute because pets do damage, right? Number two, you can never, ever, ever legally say, even if the tenant agrees to it, a pet deposit is never non-refundable. Okay, it's never non-refundable. Even if you have it in your lease and the tenant agrees that it's non-refundable, if you get in front of a judge, they're going to throw it out. It's a deposit, and deposits are always refundable up until such time as you say that they're not. and you've deducted amounts from the deposits for legal reasons, okay? I see it all the time where landlords and managers put in their lease that it's non-refundable. It is always refundable. That's the first thing. And the other thing to remember is it's not per pet. If you allow 10 cats, you can only collect one pet deposit equal to 1/4 month of the rent or 25% of the monthly rent. I also see that. Well, it's the pet deposit per pet. No, you can't do that under the statute, okay? I know for some of you it's kind of a curveball, right? But it's very important you understand that you can only collect a certain amount. Okay, questions? Anybody? Yes? Yeah. Okay. Okay, did everybody hear that? Notice he said pet rent. Understand, wording is very, very important, and words mean everything in a lease agreement. It's the legal binding document. If you're charging pet rent or a pet fee, it's not a deposit, is it? And if you put that in there as a deposit, you're kind of screwing yourself, right? Listen, if they have pets and you're going to charge pet fee or pet rent, which you should, right, that's rent. It's just additional rent for an additional occupant called the pet. And there's two types of pet rents or pet fee. You can have an upfront one-time pet fee, right? Obviously, it's non-refundable because it's rent. And then you can charge a monthly pet rent or pet fee for each additional pet that they have. So for example, I've seen this. Maybe you're going to have an upfront one-time pet fee of $100, right? Remember, that's rent. It's not a deposit. Once they give it to you, that's you. That's earned income to you guys, okay? It's rent. And I keep pounding that because that's a real it's confusing to a lot of people, all right? So in this scenario, and you should always consider doing this. We're in a for-profit business here, so we always want to make money, right? So upfront pet fee of $100. Now this can be one fee, or it can be $100 per pet. It's totally up to you. Remember, we're not talking about service animals or companion animals. We're talking about pets here. Then you can have a monthly pet rent. And it can be whatever you want. Let's say that it's $50 per month per pet. So maybe they have 2 dogs. It's $50 per dog every month. Again, it's rent. It's not a deposit, but we need to make sure that it's in our lease and it's worded correctly. Deposits are deposits, and pet rents and fees are pet rents and fees. They're totally different, okay? Any question on that? Oh, by the way, it's not, we're going to cover this in a different segment, but if it's a companion animal or a service animal and it's documented, meaning you verified it, they've made the request, you verified it, and it's been deemed an actual service animal or companion animal, you cannot collect any kind of a pet deposit. You can still collect your security deposit, but you cannot collect the pet deposit, and you cannot charge pet rent or pet fee for that animal, okay? I'm just going to leave it there in this segment, and then we'll cover this in a fair housing segment. So any questions at this point? Because I want to get into now how do we, or what's our responsibility to refund or give back the money? Okay, so let's say that we've collected our $1,250 in total deposits, remember? That's $1,000 for the security deposit, and we collected $250 for the pet deposit, so we are setting on a total of $1,250. This money must be available at the time tenancy ends. So the tenant gives notice that they're going to be moving out. Once they move out and they're officially out, meaning they give you the keys or whatever your official policy is for ending tenancy, then we have to do something with this according to the statute. Now the statute is kind of interesting in that it says upon request, or I'm sorry, upon demand is what it says. It says upon demand. Now that's upon demand from the tenant. Then the landlord or manager has 14 days to return the security deposits to return the deposit or an itemized, what we call an itemized list of deductions. All right? Now, I will tell you, it's been my experience that a lot of judges don't like this upon demand thing. Technically, you could try to get away with it. Listen, we're running the business. If the tenant's going to move out, let's get them out and move on to somebody else. So once their tenancy is officially ended, don't wait for the demand. You can if you want to, but screw it. Let's get this thing going. You have 14 days to notify them to give back their security deposit or notify them of the deductions. All right, so let's say the tenant moves out and they were supposed to do certain things and they didn't do it. So let's say we're gonna knock off $250 for cleaning the carpets. All right, maybe they were supposed to do that and they didn't. All right, and let's say that there's a broken window, so we have another $150 for a broken window. All right, so let's say that at the end, after we've totaled it all up, all right, so we have $400 of deductions here. So within 14 days, we would have to return to the tenant, in this case, because we have $400 in deductions, $850 plus the itemized list of deductions. And we send it to the last known address. If we don't have a forwarding address, then we would send it to the last known address, which is the rental property. Typically, though, if they know they're getting money back, then they may come in and get it. It doesn't matter the delivery. All I'm trying to get to at this point is $850 and an itemized list of deductions. That's what you have to do. Now, if the entire amount's going to be eaten up and there's actually money that's owed because the damages and unpaid rents and stuff exceeded the $1,250, we wouldn't return any money to them, but we would still have to give them an itemized list of deductions. And real quickly, let me just tell you, you want to document this. So you want to actually create an itemized list with the list of deductions, and you want to make sure that you keep a file keep this a copy of this in your file, and make sure that you put the date that it was completed and the date that it was sent or delivered to the tenant. Now, for you third-party managers, understand you have to keep this for 5 years in the file. That's what license law requires. There really isn't a requirement to keep things for just landlords, but I still think you should keep everything for tax purposes for 7 years. That's my personal belief. Your attorney, your accountant may say something else, but that's what I do when I do consulting. 7 years, because sometimes this is going to be considered income, and then you're going to have to account for it, so we want documentation for IRS purposes. But definitely, if you're a third-party manager, 5 years. A couple of things, the other things I want to point out here when you're delivering this. Now, carpeting. One of you guys, you asked me before we started, how do we deal with carpeting? Well, I'm going to give you the technical answer for carpeting. Now, whether you choose to do it is totally up to you. Just understand that if a tenant fights you in court and they go and they get Creighton's legal aid to help them, or the law school to help them, because the folks at Creighton University, they train their lawyers with a lot of landlord-tenant issues, so tenants will call them and they'll use this issue to train their students. Legal aid gets involved, whatever the case may be, or maybe they show up without representation. It doesn't matter. Carpeting, because it's such an expensive part of this whole part here, I want to address it. Does anybody in here know the average useful life of a carpet? What is the industry standard for carpeting? Anybody? 5 to 7 years. So when we're talking about carpeting, the useful life, the industry standard for carpeting is 5 to 7 years. Now understand that if you're going to claim 7 years, then you want to make sure that you can prove the quality of the carpeting. All right? Generally, it's 5 years. Most of the type of carpeting that we put in our rental properties has a life expectancy of 5 years. So let's say that you put in $2,000 worth of carpeting before the tenant moves in. Brand new carpeting, $2,000. All right, the tenant stays there for 2 years. How much is that per year? Anybody? Aaron, what is that per year? $2,000, what is that per year? $400 per year? So we have to depreciate this carpeting $400 per year. So let's say that the tenant was there 2 years and they trashed the carpet. That means under the law, we're only allowed to deduct $1,200 from the security deposit for the carpeting because we must depreciate carpet. And I get this argument all the time. Yeah, but that carpeting was in great shape. You know, I've had landlords have carpeting 7, 8, 10 years old sometimes. I won't even tell you about my son. My son was dealing with an apartment community here in town, and the carpet was over 25 years old, and it was in horrible shape. They thought it was in great shape, but they were like, they tried to nail him for the entire amount to recarpet the apartment. I was like, no, 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 no. Once it hits 5 years, it's considered the salvage value. It has no value. So if your tenant trashes the property and it's more than 5 years old, technically you can't collect anything. Now, I'm not saying that's the best practice or the practice you should do. I'm only giving you the technical analysis here, and a lot of it's going to depend on the judge that you would draw. Okay? So you have to depreciate the carpet, and the depreciation is not for the new amount that it's going to take. It's from the old amount, the original cost of the carpeting. Very important when you're doing your analysis here and you're doing your itemization. So again, if you're going to try to do the 7 years, then the thing you have to remember is you're going to have to prove the quality of the carpet and whether or not it falls into that 7 years. Okay? Sometimes, most of the time, all I'm going to tell you is be prepared to be, so if the tenant, if you're going to, here's the deal. If you're going to itemize and do this and the tenant asks, well, I want to know how old the carpet is, they have a right to know. If you're going to charge them for damages to the carpeting and they ask for original documentation on how old the carpeting is, you have to give it to them. All right? So, all right, any questions on returning this or the security deposit in general? Anybody? We're getting really close to lunch and I want to take the break here. So if you have any other questions, then hit me up at break. For those of you that are watching on the video, if you would please leave a comment down below if you have a question. I will answer it. And please subscribe to the YouTube channel, like our Facebook channel as well, or Facebook page if you would. It does help disseminate the information as I roll it out to you guys. So, all right, that's all I got. We'll see you after lunch.